Chhabra ma'am with us. She's a partner at Adwitya Legal and she specializes in commercial litigation and arbitration. Today she'll be talking about the gray areas in arbitration landscape and also the potential for the sector in the future. So to make the lecture more interactive, we request you to keep your cameras open if possible. And also, if you have any questions during the course of the lectures, please feel free to put that in the chat box and ma'am will take it as she goes through the lecture. Uh, just one clarification regarding the feedback forms and the certificates, because last time we received a lot of queries regarding that. We won't be circulating a feedback form. However, if you have any suggestions for us or any things that you would like us to cover, please feel free to mail us at ccadr@cnlu.ac.in. That is the email ID. Uh, and yeah, with that, I welcome ma'am to the floor. Thank you.
Hi, good evening, everyone. Madhurima, thank you so much for the introduction. I'm actually delighted to be here today and speaking to you, all of you. So, interacting with the young students of today is kind of one of my passions. So, thank you to CCADR and CNLU Patna for providing me this opportunity. So, without any delay, now let's begin. I would request if the presentation can please be shared on the screen. Madhurima, is it on screen now?
Yeah, just a second. Check.
Okay. Yes. So in the meanwhile, the participants can let me know, which year you are in and what you are currently doing. So we can start with that. You can type in the chat box and let me know about that. Okay, so we have the presentation on screen now. So as Madhurima had introduced, the topic for today is current penumbra and future opportunities. So the first part of my presentation today is basically going to focus on what are the kind of gray areas in some of the fields in arbitration. And the second part is going to focus more on what is the future of arbitration? What are we going to see in the near future? And what are the sort of opportunities which are available to people who are newly joining the field? Okay. So with that, can we go on to the next slide now? Okay, so the first topic is emergency arbitration. Now, before going into the gray areas, I'll just briefly introduce what emergency arbitration is. As of now, we don't have a specific provision for emergency arbitration in the Indian Arbitration and Conciliation Act, but usually this is found in the institutional rules of a lot of international institutions. And these rules, basically what they provide for is that if you have an arbitration clause in the agreement, and there is some urgent relief which you need to take, then what you do is that you approach the arbitration institution and you request that, look, this is the emergency that I have, this is the relief which is required, so please appoint an emergency arbitrator in the arbitration so that he can adjudication. So instead of going to court, I opt for emergency arbitration. Okay, now, can any of the participants tell me which is the most recent judgment which might have come in this field right now in emergency arbitration, if anyone has any idea? Okay, I won't wait for very long. So we'll just go on to the next slide about the judgment. Okay, so this is the most recent judgment which has come in the area of emergency arbitration. Now, what happened in this judgment was that the Supreme Court had clarified that emergency arbitration and emergency award is very much enforceable in India. And this was basically an arbitration which was an international commercial arbitration, and which basically means that one of the parties was a foreign party, but it was seated in India. Now, how the court interpreted the recognition and enforceability of an emergency award in India was that with the help of Section 17, okay, as you all know, as such, emergency arbitration is nowhere provided, like I said. So what the court said, that once the parties have agreed for SIAC rules, and the SIAC rules in turn provide for emergency arbitration, then any order coming out of such an emergency arbitration will also be recognized as an interim order under section 17. Okay. And how they dealt with enforcement is that, they said that it is enforceable under section 17 clause 2 as an interim order, similar to that. And why does section 17 apply? Basically because this is a part 1 arbitration. Now if you are aware, part 1 of the Arbitration and Conciliation Act applies to arbitrations which are seated within India. So as far as emergency orders and emergency arbitrations within India are concerned, this is, we have clarity now. Now, there is a certain hurdle which we face with this judgment, and that is that what happens if the emergency arbitration is not an arbitration which is seated in India, it is an arbitration which is seated abroad. Then what happens? So if you look at the next slide, we'll just see that what happens to foreign seated arbitration. So see, in the first three judgments which are listed above, you see the three judgments on top: HSBC Pi Holdings, Raffles Designs, and Plus Holdings. In these three judgments, what had happened was that the advocates, they had found quite a sort of innovative method of enforcing the international arbitration orders. And what they had done was they came to court under section 9, saying that, look, I have an emergency order in my favor, so now you give me an interim injunction on the same basis. Okay, this is what the parties had done in the first three cases. And the court, see, the issue is that in this case, what had happened was, in all these three cases, the court had given an interim injunction on the basis of the emergency order. So there is essentially a fresh order of the court which reiterates what is said in the emergency order. Okay. Now, the gray area over here is that, there are still issues which you could face with such an interpretation. Now, if you see the case at the bottom, Ashwini Manda, what had happened in this case was that here the court had held that since the parties had already opted for emergency order by a tribunal cited outside India, they had impliedly excluded part 1, thus excluding the application of section 9 to the case. Okay, these are the kind of risks and gray areas which still exist in this field. So as we see, there are several problems with the dual assessment. What happens is, when a court entertains this fresh section 9, it is not an extension of the emergency order, okay, but the court carries on a fresh new assessment of its own. And this assessment, the result of this assessment could very well be very different from what has been held in the emergency order. Okay. So this, of course, is a huge gap. We still don't know what happens in foreign seated arbitrations. Now, coming to the possible solutions, what can you possibly do for this? So the next slide deals with that. Now, if you come to the possible solutions, the number one solution is we could do it by agreement. Okay, so I'm sure some of you must have read it in your arbitration law also. The Balco judgment of 2012, it provides that it is up to you to, by consent, extend the application of some or all parts of Part 1 of the Arbitration and Conciliation Act to your particular agreement. Okay, so this is one solution. What you can do is, in your agreement, you can specifically say that you are making section 17 of part 1 applicable to your agreement. So the moment an emergency order is passed, it gets recognized in the same Amazon NV futures method, and it is again enforceable under 17.2, similar to what court has already held. The second solution is, of course, by an amendment. If there could be an express amendment in section 17 and they could add such a proviso in section 17, that like for example, right now what is provided in 2.2 of the Arbitration and Conciliation Act is that it gives an exception to sections 9, 27 and 37. Okay, so what they say essentially is that these sections which are there in foreign seated arbitrations apply equally. Okay, so you can use these sections of part 1 even for foreign seated arbitrations. So you could have a similar exception for section 17, and then you will be solving this problem. Okay, so this is one way of looking at it. Now, coming to the next issue at hand, next gray area. Yes, so the next gray area is unilateral appointment of arbitrators. Now, see, before going into why unilateral appointment of arbitrator is problematic, let me just tell you what is the main issue. If we look at Section 12.5 of the Arbitration and Conciliation Act, Section 12.5 provides that whatever criteria are mentioned in the seventh schedule, if you are one of those people in those criteria, then you are automatically disqualified from being appointed as an arbitrator. Okay. Now, the issue which arises in this case is that what happens if such a disqualified person is to appoint an arbitrator? Is that allowed or is that not allowed? Okay. So now let's just see what are the cases which have already dealt with these kind of unilateral appointment of arbitrators and what are the issues which arise in these cases. So the first case is TRF Limited versus Energo. This was the first variety of cases where the appointment procedure was challenged. Here, the appointing authority was the managing director. Okay, he was the managing director of one of the parties, and he was authorized to be either an arbitrator or he could nominate another person to be an arbitrator. Okay, now of course he's already disqualified due to Section 12 5 read with 7 schedule, right? Because he's a related party, he is one of the parties. So he cannot be a judge in his own cause, right? So he is disqualified automatically. The question remains, can he nominate another person to perform? So in this case, the court held no. If you are disqualified, you cannot appoint or nominate another person to do a task which you cannot yourself do. Okay, so this was the first in the line of judgments. Now, after this, also, what happened was that people said, look, I'm not allowed to nominate another person to do my task, but I can still appoint an arbitrator unilaterally, right? Because nomination and appointment are two different things. This is the difficulty which happened after this judgment. So, now coming to the next judgment, this judgment, once and for all, it held that no, unilateral appointments are no longer valid. Okay, now there are some gray areas in this field also. Now, if you move on to the next, yes. So in this slide, we'll see what are the gray areas. Okay, first of all, if you look at the first judgment, what Wolstenpine said that if suppose I am a party to the arbitration, okay, and I did not appoint an arbitrator, but I sent you 31 names of people. Okay, they are all selected by me. But out of these 31 names, you are free to choose a sole arbitrator. Okay. So, it is giving me freedom of choice of the arbitrators. At the same time, I am not the only party appointing the arbitrator. This is what this judgment said. And the court in Wolstenpine had said that, okay, 31 arbitrators is quite a bit. It is not consisting solely of your retired employees, right? So, such an appointment is going to be valid because you have given me a broad-based panel. Okay. Now, coming to the Central Railway electrification case, what had happened was that in this case, there was no 31 arbitrators. Okay, now in this case, there were only 4 names which were proposed to the opposite party. But surprisingly, the Supreme Court, this is a January 2021 case, the Supreme Court in this case also had held that since it is a panel appointment and there are 4 names suggested and you have to select one out of this is also valid, shockingly. And the Central Railways judgment is actually in challenge right now. So let's see what the outcome is. And again, in BCC developers also, there were only 3 names of retired employees. Okay, so this sort of makes the situation very murky because what happens is that I can still have full control over the arbitrators that are being appointed by giving you very selected arbitrators to choose from. And then, the main effect becomes is that it ends up being a unilateral appointment. So even though the Supreme Court says no to unilateral appointment, it ends up happening because of these sort of judgments. Okay. Now coming to the next slide, which provides for solutions. Now, if we look at this one solution, which we've already discussed, is to have a broad-based panel. Okay, 31 names was the 31 names was the quantum of arbitrators which the Supreme Court had initially accepted. So one way could be doing that, but then again, we have no clarity of how many names is sufficient, as we have seen in the judgments. Second solution is that you name an arbitrator in your agreement itself. Okay. So now, as long as that arbitrator is not a disqualified arbitrator within the 7th schedule of the Arbitration and Conciliation Act, like he is not a retired employee, he is not an employee, he is not a business partner, he is nowhere interested in one of the parties, doings. So then you can name such an arbitrator in the agreement, and then later on there cannot be an objection to such a named arbitrator. Okay. The third solution is institutional arbitration. You opt for an institution, you provide that the method of appointment is whenever we have a dispute, we will write to the institution, and then the institution will appoint a retired independent arbitrator. Okay, this is the third solution. And the fourth solution, of course, is mutual appointment. In this case, what happens is each party appoints their nominee, and then both of them come together and appoint another nominee. Okay, so this way you have a three arbitrator panel. Of course, this can be expensive sometimes, so the other methods might be more suitable in most cases, but these are the kind of solutions which you can have. Okay, now coming to the next topic. This is interplay between section 9 and 17. Okay, now if we look at the next slide, we'll just see what is the difficulty which arises. So see, this is the wording of section 9. 9.3 provides, once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that circumstances exist which may not render the remedy provided under section 17 efficacious. Okay. See, I will just recall once that section 9 is the court's power to grant an injunction, and section 17 is the arbitrator's power to grant an injunction. Essentially, what happened in the 2015 amendment was that both these are made sort of simultaneous. Both the court and the arbitrator have the same powers. Now, what happens if the AT is already in the arbitral tribunal is already in place? Can you still go to the court? So this clause 3 provides us the solution that no, you can only go to the court if your section 17 is inefficacious. Okay. Now, what are the gray areas? What is the difficulty which arises here is that what are the meanings of these words? Okay, entertained and efficacious, and the third gray area is emergency arbitration. So see, we'll just come to that. There is a next judgment on the next slide. I'll just discuss it, provide solutions to some of the problems. So just before that, yeah, no, just go 2 slides before this. Yes. So this ArcelorMittal judgment actually provides a solution to what is entertainment and what is efficacious. Okay, over here the code says entertain means, I'll just tell you what happened in ArcelorMittal first. Now, what happened in this case was that by the time the arbitral tribunal had been constituted, the court had already reserved its judgment on section 9. Okay, so the question which arose now was, should the court go ahead to render the judgment, or is the court bound to refer the matter to the arbitration, since now a section 9 would not lie unless until section 17 is efficacious, right? So over here the court interpreted entertain to mean consider by application of mind. Okay, so since the court had already reserved the judgment, that means the court interpreted that yes, you have applied your mind, and that's why you can reserve the judgment and give the judgment in this case, right? So this is what the meaning of entertain was held to be. Secondly, it said consideration goes up to the stage of pronouncement of judgment. So see, since this case had already moved ahead quite a bit, and it was at that stage, of course, then it came within the meaning of this word. Then efficaciousness. What the court said, see, the question of efficaciousness arises only once the AT has been constituted. So as we saw in ArcelorMittal, the AT had not been constituted yet. So, the question of efficacious can only come into question once the AT has been constituted. So, as such, if we see, the Supreme Court has not answered what efficacious means over here. Okay, so of course, there are still many gray areas remaining in this field. And similarly, what happens to emergency arbitrator? Like I said, now there are many institutions which have these rules of emergency arbitrator. The section 9 or 17 nowhere provides what happens then. If the AT has not been constituted, you have an option of going to the emergency arbitrator, right? But you also have the option of going to the court. But the court says efficaciousness comes into question only when the AT has been constituted, right? So there is no answer to this, that what happens in the case of emergency arbitrator, right? So these are the kind of gray areas which we see in section 9 and 17 interplay as of now. Now, of course, if someone has some questions, so please let me know. I'll answer them, side by side. I try to answer them as we go along. So now, moving on, the next, yeah, this is the next gray area, modification of awards under section 34. Okay, is it allowed? Is it not allowed? This is the gray area. Now, if you look at the next slide, this is the judgment of the project director NHI versus Hakim. The next slide, please. Yeah. Okay. So this says court has no power to modify the award under section 34. Okay. It says, see, basically the court can only do two things. Either it can uphold the award or it can set aside the award. This judgment says that the court has no power to modify the award under section 34, right? So once an award has been passed, you challenge it under section 34, the court has no power to modify it. Okay, and this is also because of the language of section 34. It says recourse to a court against an arbitral award may be only by an application for setting aside of such an award. Okay, this is why the court in this case had held no power to modify. Now coming to the gray areas in this case, the next slide. Yes. So see, despite the Supreme Court judgment existing, even after the judgment, there have been several contradictory judgments which have come, which have modified the award. Sometimes, suppose I have gotten an interest of 18% on my claims. So there are judgments which will modify the interest amount to say 9%. Okay. There are these kinds of judgments. Then this judgment doesn't talk about what happens if courts are exercising powers under their inherent jurisdiction, right? So under inherent jurisdiction, the Supreme Court in a lot of cases has applied its inherent jurisdiction and they have modified awards, right? Then the third problem which arises is if the court only has the power to set aside an award, what is the solution? After that, if your award has been set aside, you have to go in for de novo arbitration. That means you have to start your entire arbitration afresh. So what ends up happening is that you end up spending a lot of time, a lot of money re-arbitrating the entire issue, right? So this is a huge problem in this area. And it doesn't even discuss, because there is a power of the fourth issue is what if the award is remitted back. Okay. So a lot of times what happens is, again, if the award is remitted back, the AT again considers all issues and passes a new award. Again, lot of wastage of time and money. So see, now coming to the solutions, what can be done? The next slide talks about the solution. The only solution to this is bringing in an amendment in section 34, which allows court to amend the award. Okay, this is the only solution, so that all these procedures can be avoided. That is the only solution. Then we come to the next yes. So now see, the first part of my presentation, like what Madhura had explained, the first part was more related to what are the sort of gray areas in this field. And now the second part, we will be dealing with the new developments and opportunities which are existing in this field as of now. Okay, the next slide deals with the first issue is online dispute resolution. Okay, now see, let me just give a brief introduction about what ODR is. ODR is basically alternate dispute resolution, which is conducted with the help of information and communication tools, ICT tools, such as your computers, laptops, your scanners, say your mobile phones, different softwares and projectors. Okay, this is the meaning of ODR. And see, now let's just look at the present status of ODR in India. So in 2006, initially, domain name disputes were the only kind of disputes which were first converted into ODR platform. Essentially, these are document only dispute resolution. Okay, so no oral hearings are held. One party simply gives its SOC, the other party gives its SOD, the rejoinder, and whatever are the documents, on the basis of that the dispute is decided. Okay, this is what domain name disputes in the ODR field look like. Now, after a huge gap of around 10 years, in 2016, when online mediation was started in consumer disputes fairs, this was the establishment of Online Conciliation and Mediation Center, which was set up by NLSIU Bangalore. Okay, this was done under the aegis of the Ministry of Corporate Affairs, right? This was the second step which was taken after 2000 in 2016. Now, since that period, our government has been taking a lot of baby steps to promote ODR. For example, if we look at in October 2017, the Ministry of MSMEs launched the Samadhan portal for e-filing by MSMEs. Okay. Now, what happens essentially on the Samadhan portal is that you file your documents, you file your claim, but the conciliation and arbitration still happens in the offline mode. Okay. So this is a sort of hybrid sort of model, but this is also qualified as ODR. Okay, now apart from government initiatives, We can also see that there are many private organizations also who have entered the field of ODR. See, why I'm discussing this topic is because a lot of law students today or a lot of new lawyers today might not want to go into the core areas in which probably 10 years ago lawyers used to go in our generation, or maybe 50 years ago lawyers used to go in, say, litigation or corporate world. So, these are very new and upcoming options where new startups are just beginning to enter the market. So it is an untapped field and untapped potential. This is why I'm discussing this issue. See, so now apart from the government MSMEs and the government initiatives which have taken place, there are also a lot of private organizations who have entered the field of ODR. These are organizations such as, say, Agami or Sama or Pre-Solve 360, and these are some of the organizations who are doing exceedingly well in this field. In fact, I'm empaneled also with some of them, and the Ministry of Corporate Affairs has recognized a lot of these on their website. So this sort of gives a lot of legitimacy not just to government sector but also to private people who are uh, in this field right now. Okay, so just a second, I'll just take this question quickly. So Mr. Abhishek Gokhale has asked, I wish to just know that, like Singapore's seat for international arbitration, is there any plan coming in India at any place or location? Kindly advise. So, see, Singapore is a very, why is Singapore such a lucrative seat of arbitration? I'll tell you. Because the seat in Singapore means that all the laws of Singapore apply to, say, whenever you have to approach the court. Okay. So, in the arbitration proceeding, when you have to approach the court, say, for getting an interim injunction under Section 9 or challenging the award Section 34, these jurisdictions are very arbitration friendly. Okay. It doesn't take much time in the courts over there. The litigation is much quicker over there, and this is why Singapore seat is so attractive in today's world. Once there is an arbitration award, the courts will hardly interfere. Okay, now your question is whether India will ever become. See, we are currently moving towards that. If you look at progressively our judgments, what our judges are today trying to do in the Supreme Court, and I can speak about the Delhi High Court, there are so many progressive judgments. They are totally not willing to interfere with arbitration awards unless there is something which is very patently illegal. In fact, recently, this year in 2000, no, I believe it was September 2021, wherein a new judgment of the Supreme Court had come. They said that even if an award is contrary to, say, some laws of India, but they are not the main fundamental policy of Indian law, they are not a public interest domain, then even those awards will be upheld. Okay, these are the kind of reasons why Singapore has become such an attractive seat. And if we move at the pace that we are moving, number one, by changing our laws, by changing our outlook towards arbitration as a valid alternative to court proceedings, that is when we will also advance. Okay. And the second thing is your grassroots problem which we need to solve. We need a quicker litigation system. Okay, this is this, and this, they are all interrelated. Once your ADR gets strengthened, once your mindset changes, that is when India will become a seat of arbitration. So to answer your question very briefly in a few lines, yes, I do think India will become a seat of arbitration, but it will take a lot of time. Okay, it will become a preferred seat of arbitration. So let's see how it goes and where we are 5 years down the lane, 10 years down the lane. Okay, so I'll just continue with ODR now, where we were. And we were talking about how startups have entered the field. Okay, and they are doing exceedingly well. They are recognized by the Ministry of Corporate Affairs. And so and they are actually providing a lot of alternatives. Your small ticket disputes don't even need to spend crores of rupees. Your bank disputes, loan disputes, everything is being dealt with by these startups in a very cost effective method. Okay, so this is a very new area where a lot of law students, lawyers can enter right now, especially people who are passing out right now. Right now, let's talk a little about the legal status of ODR. See, apart from the basic structure found in the Arbitration and Conciliation Act, your CPC Section 89, I'm sure even if there are some students of the second year, they would have gone through Section 89 of the CPC also. So, apart from this, there are various other legislations for ADR in other fields also. And these sort of promote ODR. They are not any roadblock to ODR. Okay. the provisions of the Evidence Act and the IT Act also recognize electronic evidence and electronic signatures, right? And see, if we see, there was a recent growth in legislation in this field after COVID, especially after the pandemic hit. We started having virtual courts, we had e-courts, e-filing, and this has greatly risen. We have all separate rules for e-filing, e-courts. So as we see now, there is a lot of acceptance even in the older generation of lawyers. Earlier, there was a lot of roadblock, but now we are seeing that slowly people's mindsets are changing. Also, there are some judgments which I've just put down on the presentation. These also deal with different methods of ODR. So if we see the Shakti Bhog judgment, right, the Shakti Bhog and Trimax judgment, they recognize the validity of use of technology in the field of arbitration. Okay, like even if your arbitration agreement is contained in an exchange of emails, your section 7, if you recall, an exchange of correspondence, even if that correspondence is through emails, now these two judgments say that it is a valid arbitration clause. Okay, then similarly, if you go to Grid Corporation of India, it in this case what had happened was that there were two nominees arbitrators which were appointed by two parties, and they were then appointing a third nominee as an arbitrator, as a sole arbitrator. And this third nomination was done through online video consultation. Okay, so this was challenged basically before court. They said that no, this online consultation is not valid. They should have written letters to each other, okay, by the old method. So in Grid Corporation, the court said no, look, a video consultation is sufficient, and this is how they have nominated their sole arbitrator, so it is going to be a valid method. And this is how our courts are slowly recognizing and giving legitimacy to ODR. Okay, now in this last case, the state of Maharashtra versus Praful Desai, the court had also extended the recognition of modern modes of communication and upheld video conferencing as a valid mode of recording evidence and testimony of witnesses. Okay, so this is also a method which was recognized. Now the witness doesn't need to physically come in court and give his testimony. If it has been done through video conferencing, again, that is a mode of ODR which was recognized by court. Then if we talk in Balram Prasad, what had happened in this judgment was the Supreme Court upheld the use of video conferencing as a means to obtain the expert opinion of a foreign doctor. Okay, so the foreign doctor doesn't need to travel all the way to India to give his expert opinion in an arbitration. Simply, he has to sit there, join a video call similar to what I have joined today, and he can give his expert opinion. Okay, so the court has upheld the validity of this. So, just before moving forward, there is a question which I will just take. Okay, Mr. Deepak Arora has asked, how are records maintained in ODR? See, Mr. Deepak Arora, if you want, what I can do is I can put you in touch with a few of these startups, right, which are in this field right now, and they are doing exceedingly well. Essentially, what I see as an arbitrator, I'll tell you. So there are platforms, right, which these ODR organizations maintain. In these platforms, they have different categories of documents. So there is one category of a statement of claim which parties upload. Then the second category is a statement of defense which the parties can upload. And similarly, there are all different categories. For documents, there's a different category. For say your interim applications, there is a different category. All these categories are contained. And what I as an arbitrator simply have to, so it's something like a Google Drive, except it is much more simpler to access. So what I as an arbitrator, all I have to do is I have to access their this platform, right? I have to log into my ID. I have to access all the records. Everything is contained there. I don't need to download anything. And I have to simply view everything from there. So it is a very simple mechanism. There is no printing, no bundles which are lying in my office, right? So this is how usually records are maintained in ODR, and this is how we pass the arbitration award also. When I pass an arbitration award, I get it e-signed through my team, which is dealing with that institution. That team helps me with the e-signing process, and then that award is uploaded. So actually, there is no physical printing, scanning, anything, right? Everything happens online. This is how ODR records are maintained. I am talking about these startups because the government is actually far behind right now. What's happening in the government is they also have similar portals, but you can simply upload a document over there, and then the rest of the process happens offline. The startups are way ahead right now, and their entire process happens online, right? So that is how the records are maintained in the ODR mechanism. Now, see, if we talk about ODR, there are, of course, some teething problems, right? Like, currently, this field is very new in India. So, the kind of regulations which are dealing with ODR are very limited. We are, of course, still to see what kind of regulations come in this field, and what kind of laws the government is still to pass. There has to be a lot of laws for the kind of neutrals that are appointed, your arbitrators, mediators. There have to be some standards which have to be maintained for that. Then again, there have to be standards maintained for what kind of startups or institutions can enter into this field, and what are the standards of data protection which they have to maintain. Data protection is a very upcoming field, so we need to see how they are protecting that data, and are they responsible for preserving the data, how are they dealing with the data, who all has access to it. So all that has to still be seen in this field. So of course there are some teething problems, but yes, this is a very new and upcoming field which a lot of people can look into. Right, I'll just see if there are any more questions. Just a second. Okay, Shivani Singla says, ma'am, can you share information regarding the online startups? Yes, Shivani. So I've basically shared how these ODR platforms operate, and I had named a few. A few of them are Agami, Sama, and Presolve 360. Okay, these are the kind of platforms which are currently in the online startup field of ODR. So if you want, you can get in touch with some of them. And the second thing is that how ODR store their data and how it is dealt with. I hope I have answered your question. Okay, now coming to the next slide. See, these are some of the other opportunities and future developments which we are going to see soon in the field. And this also must be of some interest to some of you. Now, see, if we talk about the first one, this is highly undermined roles in arbitration institutions, both domestic and international. Okay, now the first thing which I cannot emphasize enough is that a lot of arbitral institutions today have young memberships now. Okay, what this essentially means is that your ICCA, your ICC, SIAC, Young SIAC, okay, all of these have free student memberships which you can become a member of. Okay, you don't have to spend anything for that. After becoming a young member of these institutions, what happens is you can attend conferences free of cost, you can gain knowledge free of cost, and you can actually start meeting and networking with the individuals who are also part of these conferences, and you can start doing that at a very young age, right? This is the basic purpose of these young institutions. And you just do a simple Google research and you will easily find how you will become a member of these institutions, and you must do it. Now, the second thing about the first topic is the careers which arbitral institutions offer. Okay, these are also highly underrated today. Only now am I seeing there is a slow shift towards the importance of being a part of these institutions. But before this, not much has been seen to be done. People don't prefer to become case managers or take up any roles in these arbitral institutions. So if you get opportunities in these institutions, please take it, search them out, and opt out for them. Okay, they are irreplaceable opportunities, I'll tell you, because I don't see how any law firm, be it a domestic law firm or international law firm, would not value such an experience. You are, after all, dealing with your statement of claim documents of so many people from different backgrounds. You are going through them regularly. You are helping arbitrators write awards. So, this kind of experience is very valuable. And again, these roles are very undermined. Okay, Abhishek, what I'll do is that I will ask Madhura or somebody else from the CCADR to circulate these names. All right, that is what I'll do. Even if you do a Google search, you will be able to come up with most of these names. But yes, after the I'll just ask the CCADR to circulate these names. Okay. Now coming to the second issue, untapped specializations in arbitration. Okay. Intellectual property, investment, and treaty arbitration. See, we must not overlook that there are many new areas which are upcoming in arbitration. Okay, till very recently, a lot of sectors, be it the financial sector or intellectual property matters, used to prefer litigation. Okay, But now what is happening is more and more complexities are arising in these areas, because it is but natural. If an area is advancing, the complexities are going to increase. Now, if we talk about intellectual property, more and more complex business arrangements and settlement agreements are being entered into, right? So, what happens is people prefer to opt for arbitration. Why? Because in these fields, specialized and technically qualified people can be arbitrators. Okay, now if you go to a normal court, there is the same judge who is by roster changing. He is doing your intellectual property also, he's doing your commercial suit also, he's doing your arbitration also, he's doing every kind of inheritance matters, everything, the same judges are doing. So if we talk about your maritime or investment disputes, there are not many technical people who are there. Okay, so this is why people have started beginning to opt for arbitration in newer fields. This is also the case for infrastructure disputes and disputes in energy sector, your regulatory disputes, and many other such areas. Okay. Similarly, for investment and treaty arbitration, also there is no option but to opt for arbitration. So, of course, in today's time, there are so many fields that I can't say that arbitration in general is getting saturated. So, there is this question which is often asked: do you feel that arbitration as a field is getting saturated? If you pick your specialization and you go in for such a specialized field, then there is no saturation. You have to be innovative about the kind of field you pick. Okay, so we need to look out for specialization. Okay, I'll just Okay, so now Swati Singh has just asked a really good question. I'll just answer it quickly. For a career in arbitration, good knowledge of what all other subjects are needed. Also, need for special skills or any tips for students. Yeah, Swati, so I'll just answer this question very quickly. And this is a very good question, actually. I really appreciate you asking this. See, I'll tell you one thing which I have seen in arbitration, and through my experience, I have seen when you opt for arbitration as a career, and you pick up a specialization. Okay, for example, you picked up construction as your specialization. You have to not only be good with the law of arbitration, you also have to be good with, number one, the technical aspects of the arbitration, and number two, you have to be very, very conversant with the facts of the case. Take the same example of a construction arbitration. In a construction matter, your project is going to be going on for at least 5 years. Okay, you should be such a good lawyer in arbitration that you should have memorized these dates of the correspondence which have been going to and fro between the parties for 5 years. Okay, if the judge or the arbitrator asks you a question, listen, when did you tell them first about this extension of time? You should have it on your fingertips. Okay, this is something which is very much required. And see, if suppose in a construction arbitration I am fighting a case where the road width was increased, and I don't know what are the terms, the technical terms which deals with this road width, or say a highway construction, then I cannot be a good arbitration lawyer. Okay, so whichever case, whichever field you are doing, you have to have a very good knowledge and understanding of the technical and the factual aspects. Okay, as far as special skills are concerned, see, nowadays there are many courses which are happening. If you feel that something is required, additionally required for you to opt for before going in for a particular case or a particular career in the field, then those are the special skills that you should go in for, but not otherwise. Otherwise, my only advice is keep reading newer cases, be up to date, and that is how you do well in the profession. Okay. Okay. Now I'll just see if there are any more questions till now. Okay. So we just, the next topic is ability to practice in international jurisdictions. Okay. So now basically the substantive law of the contract is India, but the seat is outside India, right? You are going and practicing in international jurisdiction. So again, that's a lot of exposure in the field and one of the opportunities to consider. So like I said, if you are specialized in the Indian jurisdiction, and there is a case which has a seat which is outside India, you go, you interact with a lot of people outside India. So again, arbitration is a very lucrative field still. This is what I feel. Then one topic, this is not, the third party funding. This is actually not an opportunity, but this is a very upcoming field which is going to, we are going to see in India. See, third party funding in arbitration is nothing but a sort of investment opportunity for investors. Okay. Essentially, what this means is, say, A has an arbitration, okay, and he has claims worth, say, 400 crores, but he doesn't have the resources to fund his disputes. then they don't have the money to pay lawyers, right? They don't have money to afford the fee of the arbitrators, so they need someone else to put the money. Why will that someone else put the money? Essentially because they will get a good return out of it. Okay, so if an investor feels you have a very good claim, they invest in it, and then in turn they take a huge percentage of the sum which will be awarded to you as a part of your award. These third parties are essentially people who are unconnected to your actual claim. See, right now in the Indian jurisdiction, there are a lot of setbacks to third party funding, like contingency fee is not allowed in India. And as such, there is a lot of regulatory gaps in third party funding. But I am sure this is an area which is very upcoming, and we will soon see a regime for third party funding in India. Okay. The third is, of course, emergency arbitrators. This we've already discussed. See, we need to have an amendment in the Arbitration and Conciliation Act so that emergency arbitrators are brought directly into the Indian regime, which will reduce the burden of courts. The moment you have emergency arbitrators, people will start opting for that procedure instead of burdening the courts with all their disputes. Okay, so this is also again a very upcoming area. Okay, I'll just see interplay of arbitration and insolvency laws. Yes, Amanpriya, do you have a specific question regarding this, or are you generally asking? Okay, in the meanwhile, then kindly advise about getting into opportunities in international arbitration. So, yes, Mr. Ram, I'll just discuss how you do that because that is the last topic, the paralegal roles. I'll just tell you how this can be done very easily. See, if we talk about paralegal roles, what's happening is that abroad, outside India, if you want to get into, practice abroad, there are a lot of paralegal roles which are being advertised by firms. I believe it is also a time when we will see the growth of paralegals in India. So they will be used more and more by lawyers, by firms, and by government offices. Apart from India, these rules are very lucrative outside India as well. As you know, you should really look out for these opportunities. It's a good stepping stone before qualifying as a lawyer. Okay, so to answer your question, if there is a paralegal role available, you can directly opt for it, and then in the meanwhile you can qualify in that international jurisdiction. So that is a role which you should really look out for if you want to settle abroad, you want to be more in this field. Okay, so it's a good stepping stone before qualifying as a lawyer abroad. And okay, now the next is, this PPT will be shared. Okay, wait, this is not for me. Yes. So, see, this is how you enter the field. Basically, in the last part of the presentation, I've discussed some things which you can sort of opt for if you want to have a career in arbitration. And what are the, it's that time when you stop opting for very mainstay areas and opt for more out of the box areas. Okay, so and the main purpose is to minimize your effort and maximize your return, right? So you can do these by acting on these action points, right? Okay, so I think that's about it for my presentation. Is there any specific question which you would now like to ask me? Okay, I think there is one question which I've left unanswered, that insolvency question. I'll just answer that very quickly. Okay, see, insolvency, who is the Amanpriya, right? Okay. See, insolvency, Amanpriya, I'll tell you what is the interaction basically. See, if you want to avoid that your other party should not go into insolvency, you should raise your claim in arbitration before that. Okay. The moment you raise your claim, there is a dispute which has been raised, and if you get an award out of that, then such a dispute, such an award is a very valid claim for you to put in before insolvency. Okay, but now since you said to discuss it generally, insolvency as a dispute cannot be referred in arbitration. Okay, why the question, why the reason why it can't be is because insolvency is an in rem proceeding. Okay, an in rem proceeding means that you are proceeding against the public at large. So insolvency proceedings can't be referred to arbitration. But yes, in only in personam disputes can be referred to arbitration. So if there is a dispute which you have with another party, then of course you can refer that dispute, but not insolvency disputes as such. Okay, now I'll just take the rest of, if a award is passed, then what are the possibilities to challenge? Okay, Mr. Sunil has asked this question. So I'll just quickly answer this. See, if an award has been passed, Sunil, what you can do is, first of all, you can go under Section 34 of the Arbitration and Conciliation Act. Section 34 is not in the nature of an appeal. Section 34 is in the nature of an objection petition. In Section 34, there are very specific grounds which are given to an arbitration. For example, your dispute was not arbitrable in the first place. No proper notice of the dispute was given. Then third is the ground which I was just discussing, your patent illegality, right? And then your public policy of India. These are few of the grounds which are mentioned. So the court will not enter into a reappreciation of facts and evidence, but what the court will see is, does the award withstand these kind of objection in the Section 34? If your Section 34 is allowed, then the award will be set aside. Okay, if the Section 34 is not allowed and it is dismissed, you can then go in an appeal against the Section 34 order in a Section 37 petition. Okay, that's something that you can do. I hope I've answered that question. Then, okay, Mr. Vignesh has asked a very nice question. Future opportunities for engineers. Yes, Vignesh, actually, there are a lot of future opportunities for engineers. A lot of engineers, what they do is, if they have an interest in arbitration, they take up a lot of techno-legal roles. Okay, so for that, there are many organizations which are giving qualifications for these kind of things. And the engineers, basically, they become techno-legals who help with the claim assessment. For example, the example that I just gave, your construction arbitration, in that I have encountered many engineers who qualify to be not only people who are helping with the claim assessment, seeing the technical issues, but they also become arbitrators. Okay, so there are a lot of opportunities which engineers will have in arbitrations. You can opt for these opportunities, you can qualify, and you can be even empaneled as arbitrators. So there are a lot of opportunities. Then Ruchir Jain has asked, ma'am, can we think of provisions related to appeal to an arbitral award? Like, we do not have any provisions related to that. There could be an appellate tribunal set up to sort out any claim over arbitral award passed by first arbitrator panel. So instead, de novo, we can have an appeal. Okay, Ruchir, see, the issue is that we can't have an appeal. Why? Because then the whole purpose of the arbitration is defeated, right? The purpose of an alternate dispute resolution is to not burden courts. Number one, not burden courts. Number two, have a very speedy and efficacious remedy against any dispute, right? So if you have an appeal, what happens essentially is, an appeal is, you can challenge the order in any factual, on any factual ground, on any legal ground. It essentially involves the court reappreciating the entire evidence, reappreciating the entire facts, the legal provisions, everything. Okay, what this does is that it elongates the process of arbitration. So the entire purpose is defeated. I'm not sure if you know, but in India, you have to complete an arbitration within 1 year, which is extendable by another 6 months by consent of both parties. Okay, so it's a very time bound method, and the purpose is to provide a very efficacious and speedy remedy to the party. So if you have an appellate arbitral tribunal, see, you have an appeal procedure, then it will slow down things. And I think there are two parts of your question. The second question is appellate arbitral tribunal. See, there are many multi-tiered dispute resolution clauses which parties include. Okay, so if the parties want to unilaterally opt for a multi-tiered arbitration dispute resolution mechanism, they can do that. They are free to do that. Parties have full autonomy to decide what is the procedure they want to opt for. So parties are not excluded, but to have such a provision in our law, it will really slow down things. Okay, so I hope I've answered your question. Um, Okay, now Gorisha has asked, ma'am, why is arbitration important? So, Gorisha, now see, I wouldn't say arbitration is more or less important than any subject. It's important. Basically, arbitration has provided a very, as I mentioned, a very speedy and efficacious remedy to a lot of parties. They don't need to go to courts to resolve their disputes and undergo 10 years, 15 years at the court litigation system in India. Okay, number one. Number two, arbitration is important because there are a lot of technical issues which are involved usually in arbitration disputes, right? For example, in your investment treaty arbitrations, your intellectual property, your construction, there are a lot of technical terms which are involved which an ordinary judge might not understand. So parties want to opt in for arbitration so that they can have their disputes adjudicated by a person who actually understands what they are saying. Okay, so that is the second reason. And these are the kind of reasons why arbitration is gaining a lot of traction. People are wanting to opt for out of court mechanisms to settle disputes. That is why arbitration is gaining a lot of traction. The main thing we need to ensure today is that we don't burden arbitration with as many technicalities as there are in court. You know, if you keep and start following the same technicalities, then we are going to be stuck in the same sort of rut. So we should try and avoid those kind of formalities. Then you discussed, okay, Shivani is saying you discussed a future group arbitration in the beginning. The dispute has been stretched for quite long. Is there something that could have been done at initial stages or while drafting of clause to avoid this? Okay, Shivani, this is a very good question. See, I'm not sure about the future dispute as such very specifically. But see, in every arbitration and every contract, there are, of course, drafting methods which you can follow so that these kind of disputes can be avoided. At the same time, I cannot say that there is a foolproof method of drafting. You can only foresee things which are already decided by law. Okay, and there are always going to be unforeseeable events which are going to come out of clauses, and those unforeseeable events are why our courts exist, why arbitration exists. If there were no unforeseeability in any arbitration clause, in any agreement, in any clause, then we would have no need for these kind of courts, right? So disputes arise only when there are unforeseeability in the clause. And of course, there must be a method. See, it's said that hindsight is always 6 by 6. So when you see a thing is happening before you, you always feel that, okay, in the past, this is what I should have done and this was the right method. So hindsight is always 6 by 6. But when parties are drafting an arbitration clause, even if you have the best lawyers in the country, there are going to be issues which may arise at a future date. Okay. Now, Abhishek is writing, if any matter is still pending with NCLAT, so parties still have the option to go for arbitration. So in this scenario, permission of NCLAT will be mandatory required. No. See, Abhishek, what happens is that in NCLT and NCLAT, there is a moratorium period which starts. Okay. Unless that moratorium has been lifted, no party can opt in for arbitration. And yes, as you rightly mentioned, if the moratorium has been lifted and the matter is still been going on, first of all, that is going to be a rarity. I have never seen that happen. The moratorium is operating usually when the matter is pending. Okay, secondly, if yes, the matter is pending in NCLAT and there is no stay, nothing is there, no moratorium is there, then yes, you need to take permission from of the NCLAT to opt in for arbitration, because essentially what you are doing is you are going for a company which is still undergoing restructuring process, right? So you need the permission of the court, the NCLAT, to go in for your arbitration proceeding. Okay. Now, in case award is dismissed, is there again arbitration de novo? Yes. Deepak, very good question. So like I said in my presentation also, now see, award is not dismissed. Okay, basically an award is set aside. Okay, so now what is the option? Yes, the parties have to go in for de novo arbitration. So if suppose you went in for arbitration in for a section 34 challenging the award, and only one portion of the award was set aside, then you have to go in for de novo arbitration for that issue. And if suppose the whole award is set aside, you have to go in for de novo arbitration for the whole all the issues. So that is a very time consuming process, and that is why I said this is a huge problem in this area right now. Okay. Now, yes. So now Shashti Brata has asked whether order passed by civil court under section 9 is binding on arbitral tribunal under section 17. Okay, see, a very, very interesting question actually. See, Shashti Brata, what happens practically speaking is that usually when the court enters in the section 9, they give a very limited relief. This is what is happening nowadays. They give a very limited relief. Okay, they try not to enter into the main facts and the main disputes between the parties. And usually in a section 9 petition, the court specifies that this is only going to be a prima facie finding on the disputes. Okay, and the arbitrator is free to reach his own conclusions. This is what a section 9 usually says. Okay, So see, it's binding if the court says that yes, this part is going to be binding for you, but otherwise it's not binding. But again, Sasibrata, this is a rarity. The court usually never goes into the domain of an arbitrator. The court only gives a prima facie finding in a section 9. It doesn't even give a finding. It just gives a prima facie conclusion sort of on the facts, and it gives the relief to the parties. So in one way, it can be said that it is not really binding because the order itself says that it is not going to be binding. Okay. Okay. I'll just see if there are any more questions quickly. If the arbitration clause is not mentioned in the agreement for dispute resolution, then it's possible for the go directly court for dispute resolution or file the writ petition. Okay. Arvind, I think your question is that if there is no arbitration clause in the agreement, can you opt in for arbitration or do you have to go to court? Okay, I think that is the question. So see, Arvind, basically, what happens is, I'm not sure if there are any fourth year or fifth year students. You must have read in your arbitration act also that P. Raju Anand judgment. Okay, so basically, what happens is that according to Section 7, you can opt in for arbitration by consent even after your dispute has arisen. Okay, so even after your dispute has arisen, you can opt in for arbitration, and you can do that either by email or by entering into a separate deed or an agreement. So it's not necessary that before the dispute began you should have opted for arbitration. It's not necessary. And the second thing is, even if you go to court and you express before court that look, I want to opt for arbitration, and both parties are agreeable, consent is the key for arbitration. Okay, so if both parties consent that yes, we want to go in for arbitration, even before court you can submit it, and the court will refer you to an ADR mechanism under Section 89. Okay, so that is the method, right? Now moving forward. Okay, Somnath Thakur has asked, even after putting arbitration clause, parties opt for pre-arbitration proceedings or want to delay the arbitration. Why is it so? See, Somnath, what happens is that if they put an arbitration clause, the pre-arbitration proceeding that you are talking about are usually opted for in the arbitration clause itself, right? So if the parties have opted for it, that means they wanted to go in for the pre-arbitration so that they can avoid going into the main dispute resolution, right? So the parties opted for it. That is why they want to go into the pre-arbitration mechanism. And delay arbitration, see, this is a filthy tactic which is, adopted by a lot of parties. If they don't want to pay the money, they think yes, I am at fault, then they will automatically, want to delay the arbitration proceeding somehow. So these are delay tactics which are adopted by a lot of parties. Okay. Now, are there any more questions? I'm just going through. Can a party to an insolvency? See, Ram, what happens is that if an insolvency proceeding has been initiated against a party, like I explained, there is going to be a moratorium. A moratorium essentially means is that you cannot opt in for any dispute resolution or any any methods in which you can take money out of the insolvent party, right? So if an insolvency has been initiated, you cannot invoke arbitration. If the award is dismissed, then why go to shouldn't be the court? Yes, Shivani, this is what I said. Right now, the court is not allowed to modify the award. Okay, this is the crux of what I had shared. Right now, what the Section 34 provides for is you can only opt for setting aside of the award. And this is what is creating problems because this is such a lot of waste of time and money. You have to go in for de novo arbitration. Okay. Are there any more questions now? Okay, I think that's about it.
This brings us to the conclusion of today's event. Thank you so much, Gunjan ma'am, for taking out the time and for such an insightful and interactive session on the grey areas in the field of arbitration and the new developments and opportunities that we all can look forward to. It was a pleasure to have you with us today. My heartiest thanks to everybody who took out the time to join us for this guest lecture and made it such a big success. Thank you all for joining us. We hope to connect with you all again very soon. Till then, keep safe and have a very good evening. Thank you all.
Thank you. Thank you